Well, some new reaction to the Supreme Court's ruling striking down a key section of the landmark Voting Rights Act passed to prevent discrimination at polling places. The High Court declaring the requirement that certain areas get Justice Department approval before changing election laws. They deemed it unconstitutional. The rule applied to 8 states you see in orange and also to counties and townships in a half dozen other states. Attorney General Eric Holder says he's deeply disappointed by the ruling, but warned the Justice Department would still monitor jurisdictions around the country for voting changes that may hamper voting rights.
We will not hesitate to take swift enforcement action using every legal tool that remains to us against any jurisdiction that seeks to take advantage of the Supreme Court's ruling by hindering eligible citizens' full and free exercise of the franchise.
We'll get more to the rulings from today, but this is one of the big cases as well before the Supreme Court, and we obviously got the ruling yesterday. Peter Doocy is live in Washington with more on how this story has really developed. Peter?
And Jenna, the impact of yesterday's ruling is already being felt. The Supreme Court decided that nobody here in D.C. needs to pre-clear changes to state election procedures, so states can change the way they conduct elections if they want, and some already are. Down in Texas, beginning tomorrow, anybody who wants to vote needs to have a photo ID, and if potential voters don't have driver's licenses, they must go get a free photo ID from the state. Leaders in Mississippi have already also said they want quick changes to their state's voter ID laws, and supporters of this court's decision are pleased with the freedom the courts have given the states.
Our laws are one size fits all, not separate laws for Georgia and Arizona that places like New York and Idaho don't have to comply with. So I think a great constitutional order has been restored today, and that's a wonderful thing for our system of government.
There was a lot of disappointment, though, expressed by top Obama administration officials yesterday. The president himself came out and called on Congress to pass new legislation that guarantees equal access to the polls for all Americans, and that's something the NAACP wants as well.
Congress, in this moment, must take this seriously, must seize this opportunity to, together in a bipartisan way, seek to reenact a measure that will protect the voting rights of those voters who have been vulnerable since 1965 when the Voting Rights Act was first passed.
This key part of the Voting Rights Act was struck down yesterday by the Supreme Court in a 5-4 decision, as close as can be, and the same margin as the decisions in today's same-sex marriage cases. Jenna?
Peter Doocy, thank you.
For more on the Supreme Court decisions, let's bring in Juan Williams, a Fox News political analyst. Charlie Hurt is also with us, a columnist at the Washington Times. Juan, you're saying that the Supreme Court got it wrong. Why?
Well, I think the key to the argument, John, as presented by Chief Justice Roberts, was that this law is somewhat antiquated, that in fact it's based, the preclearance provision that you just heard discussed is based on data that came from the 1970s. It's 40 years old. There's no evidence that in fact these states are any more discriminatory in their practices than anybody else, any other state. But in fact, as you just heard from Peter, you have states like Texas that were blocked in the last election cycle from gerrymandering some districts, changing voter ID laws that in fact were proven to depress minority voter turnout. So this is a very current issue, having people disenfranchised in this country. And I would add one other quick fact, which is that if you look at the politics of the moment, there's real advantage to many Republicans to depress minority turnout because minorities, blacks and Latinos, overwhelmingly vote for Democrats. So there's a reason for one political party here to want to disenfranchise voters who support their opponents.
Well, doesn't every political political party, if it has control of the State House and the governor's office, doesn't it do what it can to enhance its political prospects in the state?
Absolutely, but the important thing to remember here, John, is that if there are legitimate claims of people being suppressed from voting, people being denied their constitutional right to vote, the Department of Justice still has every bit of authority to go in and investigate and take appropriate action. But the notion that somehow that it's an effort to suppress legitimate voting by requiring people to present a photo ID in order to vote. You need a photo ID in order to buy a pack of cigarettes or a can of beer. the notion that that this is an attempt to suppress legitimate votes from minorities is I would argue is actually an attempt by liberals or Democrats in order to advance their political standing through very, very questionable claims.
Yeah, Juan, I want everybody who is legally entitled to do so to be able to vote, but I also want to make sure that dead people aren't voting and that people aren't voting 4 times and that, people who aren't citizens aren't voting. Isn't an ID an answer to all of that?
It could be, but I mean, look, there's no evidence of voter fraud. If there was evidence of widespread voter fraud or people presenting, fake IDs or something, I'd say we have a problem. We don't have a problem in that regard. What we have instead, evidenced in the last election cycle, are cases where people will gerrymander districts, as was the case down in Texas, where you had a federal court said this is really depressing the power of Latino and black voters in the state of Texas, and now you have the Supreme Court overrule that, and so Texas will go back on it. It's not just about the voter ID, it's about purging voter rolls, changing the hours at polls, closing polls in certain areas. These are steps that are taken with the express intent of limiting the power of minority voters who vote, as I said earlier, overwhelmingly Democratic.
Juan, I could not agree with you more about the sort of injustice and disgusting nature of all of this gerrymandering based on racial profiling or racial discrimination. But you have to admit that the single most the strongest force requiring us to discriminate against voters based on race is the Voting Rights Act of 1965. It requires that districts be drawn based on the racial makeup of the voters. And most of America has moved on, has moved past all of this stuff. And yet the federal government is requiring politicians to continue to build congressional districts based on the race of voters, which I find patently offensive. But of course the politicians love it because they can it ensures that they can remain in power. Black politicians and white politicians work together and they trade these voters back and forth in order to stay in power.
All right, we're going to continue to cover this issue. Obviously, the Supreme Court has spoken, but it's going to be boiling in the weeks and months ahead as the Justice Department and others and the states actually make some changes. Charlie Hurt, Juan Williams, thank you both.
Thanks, John. Thanks, Juan.